Aoife Lucchini. I'm an estate planning attorney here in Clark County, Washington, and I have a passion for advocacy for the disability community. I serve on the board of Peace Northwest, which is a boots-on-the-ground nonprofit, a resource for individuals with intellectual and developmental disability, IDD, and their families. Most of my legal work is estate planning, wills and trusts, but for individuals and families in the disability community, that includes special needs trusts. I serve clients all over the state of Washington. I used to do guardianship work. I don't do that now, but what I do is I help families looking for alternatives to guardianship, the supported decision-making pathway, about which I'm going to share today. This presentation is about supported decision-making as an alternative to guardianship. Supported decision-making is giving you, a person who experiences life with disabilities, the information you need and want in a way that you can use so that you are able to make the best decisions for yourself with the supports that you need and deserve, and without the need of a guardianship over you. Is this an option for everyone with disabilities? No, many people do need a guardianship. But supported decision-making is for you if you are able, with appropriate supports, to take in information, evaluate that information, and make decisions about your own life, and then communicate those decisions one way or another, and all with the supports that you need and deserve. And you need to be lucky enough to have trustworthy people in your life to serve as your support team. Supported decision-making is about recognizing your decision-making potential and growing it. How you make decisions every day, just like people without a disability. You need help making decisions, just like people without a disability. Most adults need help making decisions, reading leases, contracts, doing their taxes. That's why they rely on trusted advisors like accountants and attorneys to help them make decisions. This is sort of like that for you. Just because you have a disability doesn't necessarily mean that you need your rights stripped away from you and given to a guardian. Who is this presentation for? This presentation is for you, teens and adults who experience life with IDD, intellectual and developmental disability. It's for your supporters, your parents, your family, the people on your team, and it's for professionals who are ready to think differently. Here are the questions that we're answering today. Is guardianship always necessary? What is supported decision-making as an alternative? What does it look like legally? What does it look like in real life? And how do you get this? And if you're already under a guardianship, is it possible to unwind that guardianship? Is it possible to switch to supported decision-making? And I want to clarify, when I say guardianship, I mean what we now call here in Washington State, guardianship and conservatorship. Those are newer terms here in the state of Washington since the new law in 2020, and I'll explain more about that later. Guardianship for our community is a shoe that doesn't always quite fit. The concept of guardianship wasn't made for the disability community. It's more for an elderly person who is losing capacity to care for themselves. Think of an 80-year-old person with property and money, and they're experiencing a decline. They're not able to protect their own interests, take care of themselves anymore. Perhaps they're giving their money away, money that they need for their care. Maybe they're experiencing dementia, and that's increasing. The arc of their capabilities is generally a downward line. They aren't building independence. They're not gaining skills. Rather, they're declining, losing the ability to care for themselves. And that is the scenario that guardianship attorneys deal with most of the time. But our community is a whole lot different. Now, of course, we have a huge spectrum of abilities and disabilities. And of course, there are people that obviously will need a guardianship. But we have many teens and adults with IDD who are growing their skills, building their independence, working to maximize their abilities. They take in information, they evaluate it, they make decisions about their life all the time. What to eat, what to wear, what sort of video games to play, what classes at school they like or don't like, what sort of work they like or don't like, what kind of job they want to have. Many take the bus, drive a car, have a job, have friends, have a romantic interest. Some or all of that. Teens and adults with special needs, you have challenges, yes, and you are growing and learning and working hard to become as independent as possible. Everything that you did at school, with your IEP, job skills training, all of that was to help you continue to learn and grow and stretch. Building independence is the name of the game, building your life. Your trajectory is an upward line. And I want you to know that guardianship isn't the only option for you. So let's talk about what guardianship is. Historically, when you turn 18, the legal age of adulthood, and you have an intellectual or developmental disability, your parents are told that guardianship is the next step. Everyone tells them this. The school administrators, doctors, just about everyone says it's time for a guardianship. It's what everyone knows and it's what's always been. The belief is that you can't be a true adult because you have a disability, that you shouldn't have sovereignty over your own life, that you can't handle the rights of adulthood and full citizenship, and you need a court to take your rights from you and give them to someone else, usually your parents, so that they can make all the important decisions about your life for you for the rest of your life. It's seen as the only way to protect you. Parents go to a guardianship attorney, and the attorney doesn't necessarily question whether you need a guardianship. They do what they're paid to do. They file a guardianship petition on behalf of your parents. And that starts a process where a lot of people chime in to recommend a guardianship. And then the judge, guess what, orders a guardianship. So let's do a quick overview of that process. So it starts with an attorney who files a petition for guardianship. Then a court visitor, it used to be called a guardian ad litem, but a court visitor comes to meet you. The judge isn't going to come off the bench out of the courtroom to meet you. They send a court visitor. And this person is going to inform you, the individual with disabilities, that there's a guardian petition that's been brought, that you're entitled to an attorney, and one can be appointed for you if need be. They're going to gather medical reports, professional reports, to confirm your disability and get opinions as to whether or not a guardianship is recommended. That court visitor is then going to make their own report to the court and recommend whether you would benefit from a guardianship, and who would be that guardian, and the extent of the guardianship. The judge usually follows the court visitor's recommendation, and often a guardianship is ordered and put into place. A guardianship removes your civil rights and liberties. Some of the rights that get stripped from you, basically the right to be a full adult with control over your life, the right to enter contracts, to sign a lease, for example, the right to make personal health care decisions for yourself, the right to vote, the right to marry, the right to do a will. Oftentimes, the right to vote gets retained, but the rights to make most decisions over your life will be taken from you and given to your guardian to make those decisions for you. For parents or family members, This court process of getting guardianship and getting appointed as the guardian, that's actually the easy part, because being a guardian means lifetime court oversight, and it's not easy at all. The guardian has to file their plans for you. They have to file ongoing reports with the court about how you're doing and your finances. They have to report any changes in your circumstances. And notice has to be given to certain people in a certain way. If the reports come into the court and they make sense, that's the supervision. But if something's missing or the court wants it in a different format, the court's going to send a notice to the guardian and say, come on in for a hearing and explain yourself. Guardianship laws change, procedures change, and a guardian has to keep up with all of that. Being a guardian is no small job. At some point, the person serving in this role will likely need an attorney to help them once again. Frankly, being a guardian is a bit of a pain. It's not something that people end up saying, wow, that was much easier than I thought it would be. And then what about someday when the guardian passes away? Now the court will need to appoint someone else to serve as guardian. It could be a sibling. It could end up being a complete stranger, a professional guardian. And these are questions that parents should ask a guardianship attorney when they first go to petition for guardianship. What happens someday when we're not here? Who then? So, again, what does a guardianship do? It strips an adult, it strips you of your rights, and the idea is that it's for your own good. It's the idea that it has to be done to protect you. How does it protect you? Well, not with precision. There's a lot that a guardianship doesn't do. Parents, a guardianship does not keep your 18-year-old from adulting. It doesn't mean that you get to decide if they go on dates, if they have romance. It doesn't mean you get to say who they get to be friends with, who they get to associate with. If there's someone exploitative in your young adult child's life, the guardianship doesn't interfere with that. You would have to go get a vulnerable adult protective order to get that person out of their life, and you would have to show that that's necessary. Guardianship also doesn't mean you get to make someone live where they don't want to live. It doesn't create a full bubble of protection like parents hope that it would. So knowing all of this, know that a guardianship isn't necessary for everyone. We have a new way of thinking about guardianship, and disability advocates have been working on this for decades. Here in Washington in 2020, the guardianship law was changed for the better. Now you can find this law at the Revised Code of Washington, RCW 11.130, and it's called the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. And what it does is it establishes supported decision-making as an alternative to guardianship. Not everyone knows about it, not everyone understands it, but this new alternative is here, it's in the law, and change is happening. After today, you will know about it, you will understand, and you will have the words to advocate for this alternative if it's appropriate for you and your family. So here's what the law says. It says, it is the intent of the legislature to protect the liberty and autonomy of all people of this state and to enable them to exercise their rights under the law to the maximum extent consistent with the capacity of each person. And it recognizes that people with disabilities have unique abilities and needs, and that their liberty and autonomy should not be restricted through guardianship or any other protective arrangement except to the minimum extent necessary to adequately provide for their health and safety and to manage their financial affairs. So that means that's the least restrictive alternative rule. It means we want to protect someone with disabilities and help them, but we can only do so with the least restrictive alternative. Kind of reminds me of the IEP process that we're familiar with. The new law is a reframe in thinking. There's a lot of new terminology. And for those who are already a guardian or in a guardianship, you may know some of these words, and now you need to know how these words have been changed. So for example, it used to be that there were two parts of a guardianship. Guardianship of the person, which is decisions over your health and personal decisions, and guardianship of the estate, which is decisions over the money, your finances. Well, the new law changed those terms. So now guardianship of the person is a guardian, and guardianship over the estate, the money part, is called a conservator. Other words that have been changed, the guardian ad litem is now called the court visitor. Instead of calling the person over which we have a guardianship an incapacitated person, we now more kindly call them the protected person. Letters of guardianship are now called letters of office. If anything, this is just to show you that if you're going to be a guardian over someone, you have to keep up with the law and changes in the law. It's not an easy job. But what I'm really here to talk about is the reframe in thinking of the new law. The old starting point seemed to be if you have a disability, then you're incapacitated almost by definition, and you need a guardianship. You need someone to make decisions for you. Now the new starting point is what supports do you need to help you make your own decisions about your own life? What's the least restrictive alternative? And that's baked into the law now. The last resort should be guardianship. The difference is respect for you, the individual with a disability. So as I said, requiring the least restrictive alternative is now baked into the law. If you look at this section of the statute, the law, the basis for the appointment of a guardian for an adult is where that person lacks the ability to meet essential requirements for physical health, safety, or self-care because they're unable to receive and evaluate information or make or communicate decisions, even with appropriate support services, technological assistance, or supported decision-making. So that means if you can do all of those things with appropriate supported services and technological assistance and supported decision-making, you shouldn't have a guardianship. Again, if you look at the statute, it says that to appoint a guardian, it has to be necessary to prevent significant risk of harm, and the person's needs cannot be met by any other arrangement instead of a guardianship or some less restrictive alternative. Your doctor or your diagnosis does not decide if you need a guardianship, and that's in the law as well. The appointment of a guardian is a legal decision, not a medical one. So even though your doctor may recommend a guardianship and may say that's what's next when you turn 18, they may not know about supported decision-making. They may not know about this alternative. So their recommendation is not what determines whether or not you actually need a guardianship. Parents, there's a fork in the road when your young person with disabilities is heading towards age 18. You can petition for guardianship, or you can set up the supported decision-making model. Petitioning for guardianship, stripping away rights, and having supervision by the court for the rest of that person's life. Or none of that, which is the supported decision-making model. No court process, no court supervision, no lifetime of reporting to the court. Now keep in mind, as I said, for some, a guardianship is the only option. I'm talking about those individuals for whom it isn't appropriate necessarily, who have the ability to make decisions for themselves with supports. So let's bring supported decision-making as an alternative to guardianship into focus. According to the law, supported decision-making means getting help from one or more helpers of your choosing to help you understand the nature and consequences of personal and financial decisions, to help you make the decisions, not make them for you, and help you communicate your decisions. So, who is this for? Again, this is for adults who experience life with a disability who do have the ability to make decisions about their own life with the help of chosen supporters. For example, reading a lease and understanding what it says and what it means. Maybe that individual needs a little more information, a little more explanation, a patient review of what the provisions in the lease say. Maybe making a nutritious meal plan and understanding and learning and practicing where and how to buy groceries and prepare meals for oneself. It's kind of like having a para for adulthood. Your team is going to be helping you. So what does supported decision-making look like legally? Again, you don't go to court for this. It's not like petitioning for a guardianship. Instead, you'd go to an attorney and you'd do some different kinds of documents. You'd do a document called a power of attorney, and then you could also do a document called a supported decision-making agreement. Who am I talking about? I'm talking about you, the person with the disabilities. You get an attorney to help you make these documents and sign them. So supported decision-making starts with your power of attorney document. Every adult needs a power of attorney document. These have been around for a long time. This is not a new concept. A power of attorney is a document where you say who can make healthcare decisions for you if you're not able, and who can make financial decisions for you if you're not able. In fact, you can actually have someone have the authority to make those sorts of decisions or help you with those sorts of decisions while you are able. So it's a way to authorize someone to be able to access your financial information and your medical information, someone you trust very much, so that they can assist you. An adult with disabilities can do a power of attorney if they can understand the concept of what they're doing. It will include a HIPAA release. That's what allows someone to help with medical things, making doctor's appointments and getting access to medical records and those sorts of things for you. Now, many attorneys don't have experience with clients who have an intellectual or developmental disability, but some of us do. So when you're ready to do your power of attorney, go to an attorney who does have experience and understanding about the disability community. Find an attorney who's able to sit down with you and have a nice, patient conversation and explain this legal document so that you understand it. Now, the next document, the second document, is a supported decision-making agreement. And this is a new thing, but it's in the law. It's in the new statute. What a supported decision-making agreement is where an adult with a disability voluntarily decides to make an agreement with a supporter or their team of supporters, saying, this is how I want, this is the help that I want, how I want to ask for it, how I want to get that help. These are the things you're going to help me with. It sets up a pathway for everyone to be on the same page, everyone to be on the same team to support you as you're making big decisions about your life, big decisions and small decisions about your health care, your personal decisions, where you're going to live, and your finances. how you're going to spend money, and all those sorts of things. A supported decision-making agreement, just like a power of attorney, is a written agreement, and there's some requirements to it. It has to be signed and dated with some witnesses or a notary. And the agreement ends whenever you decide you want to end it. Now, who can be part of this? Well, your family members or trusted friends. Who can't be chosen as a supporter? Well, paid caregivers are not going to be your chosen supporters under the supported decision-making agreement unless they're also your family members. And who can rely on this agreement? Well, that's still sort of getting fleshed out in the world. I don't think that banks or medical offices are going to rely on a supported decision-making agreement to giving authority to someone else to have access to your financial or medical information. That's why I think we still need the power of attorney document. But I view a supported decision-making agreement, at least at this point in time, as a family agreement. It's a focal point for a great reframing conversation. It's a inflection point where a parent can think about what it's like to be, instead of a parent of a child with disabilities, now they're a parent of an adult. And that's a different kettle of fish. How can we keep this adult's life thriving? How can we keep them growing? How can we keep them building their independence? That's what I think this agreement helps a parent think about. How can we support the trajectory and growth and independence, that upward line? What does a supported decision-making model look like in real life? Well, it looks like this. Hey, adult with disabilities, you're in charge of your own life. You build your team of supporters. You decide who do you trust to help you make decisions, big and small. It means putting together those legal documents so that you can share, you can give authority to the people you've chosen to help you, so they have the tools to actually be able to help you. That durable power of attorney and that supported decision-making agreement. And it means a reframe in relationships. It means a reframe in the parent-child relationship, as I just described. And it means asking the question, who drives the bus? Whose journey is this anyway? One concern that especially parents have is, what about scammers and tricksters and people that might try to exploit my loved one? And I think the key is building a solid relationship of communication and respect, building solid pathways so that your adult will be able to say, hey, this has come up in my life. I'm not sure what to do. Would you please help me make a decision? One of the great tools that's out there is a TrueLink card. And the link to the website for that is on this slide. A TrueLink card is a prepaid debit card that allows a supporter to truly support in decision-making around finances and how money is used, money that the loved one has access to. So I encourage you to look into that. And there's other ways that bumpers can be put up to protect the financial assets at issue. For example, an ABLE account with an authorized representative, trustees of a pooled special needs trust, and of course trustees of a standalone special needs trust are all going to be gatekeepers of funds that go to assist that loved one who is impressionable. I understand that. I'm a parent too. These bumpers and these tools are out there to help. So what if you're already in a guardianship, or you're a guardian for a loved one that you really feel could benefit from supported decision-making instead? Can you unwind the guardianship? It's possible. This is a new thing, though. You're going to have to ask a court to terminate or modify the guardianship. And just like everything else, you're going to have to fight for this. But in the statute, in the new law, it makes clear the court shall hold a hearing if you ask for it. So if an attorney petitions to modify or terminate the guardianship, the court shall hold a hearing about that. Or any communication from the adult under guardianship or the person, anyone interested in their welfare, should lead to a hearing before the court. Or when the guardian does their periodic reports to the court, they can ask for a hearing and say, I think it's time to modify or terminate this guardianship. And I would attach a copy of the law, RCW 11.130. I would always do that and be ready to fight and educate. What do I say? Well, you say, I'm under guardianship and I think that a lesser restrictive alternative would be more appropriate for me, and I'm requesting a hearing. Or if you're the guardian, you would say, I'm the guardian and I think a lesser restrictive alternative would be more appropriate for this person, and I request a hearing. Now, I can't give you legal advice. I don't know you and I don't know your situation, but I'm giving you the pathway to start this conversation with the court to consider unwinding a guardianship. So is this a DIY sort of thing, a do-it-yourself thing? Sure, you could try that, or you could hire a local guardianship attorney, one with a heart for alternatives to guardianship. But you're gonna have to explain to everyone this new concept of supported decision-making. Now, I don't do unwinding guardianships myself, and I'm, again, not giving you legal advice about your situation, but I'll tell you what I would do if I were a parent or a person under guardianship. I'd be very ready to explain and to educate to an attorney that I've hired, or to a judge, or to a court visitor, exactly what I want to put in place as supports instead of that guardianship. I would explain the supported decision-making model. I would say, here are the supporters that are here for me, and I would name them. I would say, this is my situation. I live in this setting, and describe it. I manage my own belongings. I manage my own social schedule. I intend to execute a power of attorney for financial decisions and personal and healthcare decisions. I trust my supporters, and here's how we plan to keep my money safe from abuse. I would share about using a TrueLink card, for example. These are the bumpers that are going to be in place to protect me from any sort of financial abuse. I would explain that my extra money goes into perhaps a pooled special needs trust account with the Developmental Disabilities Endowment Trust Fund. I would explain that trustee is the Arc of Washington, and that my supporter assists me in asking for appropriate distributions. Or I would explain that my extra money goes into an ABLE account, and my supporter is an authorized representative to help me decide what to use that money for. I would explain that I plan to execute a supported decision-making agreement to clarify with my trusted supporters the sorts of help I need, how I'm going to ask for it, and how they're going to give me that help. I would explain that with patient assistance from my supporters in understanding decisions that I need to make about my own life, I can make decisions, financial and personal, for myself. I would explain that my supporters help me build independence and that I am learning and growing my skills every day. The concept of supported decision-making is new in the law, it's new to the legal community, but it's not new to the disability community. There's been a movement for decades to improve the lives of individuals with disabilities. And that movement needs you. These legal changes were the result of advocacy work by individuals with disabilities themselves, self-advocates, their family members, their parents, professionals, and legislators up at our state capitol in Olympia, all supporting this new way of seeing you, an adult who experiences life with disabilities, with respect. I encourage everyone to hear this call to participate in this movement. We have advocacy days through the ARC of Washington State. You can be part of speaking to our legislators up in Washington about bills that are being considered right now that will improve the lives of individuals with disabilities. You can join a local ARC chapter. You can join SAIL, Self-Advocates in Leadership, which is truly an amazing group of individuals with disabilities who advocate for themselves and others all over the state of Washington. And of course, you can dial into your local nonprofit and serve on their board, perhaps, volunteer. Check out peacenorthwest.org and see what they do and how you can have that in your county as well. My presentation today is in honor of Judy Heumann. She's considered the mother of the disability movement. She passed away in March of last year, and I really recommend that you read her memoir called Being Human. She was an amazing woman and has done amazing things that our families now benefit from. I also recommend watching a documentary on Netflix called Crip Camp. Judy is in that documentary. It's a really amazing piece of filmmaking, and I hope you watch it. It will change how you think about your loved ones with disabilities, and if you have disabilities, how you think of yourself. I certainly learned a lot from it. Add your voice to the effort. Be the change that we need to see in the world.